decision on that yet. Bennett is coming, evidently.
So I think we're going to do business work session in the morning. Bennett's coming at 11.
I don't know if either one of you guys in the middle received that. I said, no reason for me to.
Pass on.
Limited,
I already answered.
I think it would be wise for a few of us to go if we can. I'll try to be there. It's always a little tricky, but
And it's limited to 10. Because
one or two.
yeah. Okay.
Is Doug joining this meeting? He's not. Oh, no.
Good afternoon, Commissioners. This is Troy, your host. Looks like we're just waiting for Doug. I do not see him online yet. Does anyone know if he's coming into the room?
Who is this? Oh, okay. Nice.
Good afternoon, Commissioners. This is your host, Troy. We are live and recording.
Good afternoon. Welcome to the Board of County Commissioners Special Public Hearing for December 18th, 2020. We do have a quorum. All commissioners are in attendance, and welcome to our live and virtual meeting. Would you please stand and join us in the pledge? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you, everyone. Mr. Ingalls, do we have certification of our agenda today?
We do, Mr. Chair. This item was previously continued from December 15th until today. With that, you have proper notice and jurisdiction to move forward.
Thank you, sir. And are there any disclosures from any commissioner for any item on our agenda today?
I have none, Mr. Chair. Thank you.
And I have done, Mr. Chair. Thanks.
And I have none. Our item is 2A. This is Sterling Ranch Plan Development, an amendment to water appeal, project file MI 2020-010. Presenting for staff, Jeanette Barr. Jeanette
Actually,
Bear.
And I actually think that Brett Thomas might be presenting. He's remote, but maybe we'll have him say a few words, or I can say a few words as well.
Thank you. Brett, are you on the line?
I am here, Commissioners. Sorry.
Okay, so will you present?
I do not have a formal presentation. We did receive a request today from the applicant for a continuation until January 26th. Staff did also provide some revisions as directed by the board at Tuesday's hearing in a memo dated December 17th.
Okay, very well. Thank you, Brett. So I'm going to just state this is an unusual circumstance because the board continued this hearing today from Tuesday, December 15th, and we continued the hearing while we were in board deliberation. And at that point, we had closed public comment and we had closed any further information being accepted. So our hearing today is to be a continuation of our deliberation. So I want to bring that point forward. And commissioners, any particular comment, questions?
Well, I would agree, unusual circumstances, but certainly to the extent we can be adaptable to our citizens and businesses, we like to be able to do that. My understanding from our last hearing is that we were being provided with hopefully some updated information associated with some of the deliberations that we had from last time. I know that we did receive an email the other day with an update from staff, including some of the changes associated with Mr. Lytle's particular suggestions for additional information. I suppose I could only frame this as a request from the applicant that we continue, and I don't know that that would be outside of our purview, but I would ask Attorney Ingalls if perhaps he could provide us some legal advice on the procedure for today.
Thank you, Mr. Commissioner. I'll try. It is a little bit of an unusual circumstance. You, from time to time, and not infrequently, receive requests from applicants for continuances, and I would say it's pretty common for the board to approve those requests. But it's uncommon that you would get those requests in the middle of deliberations after you've made clear that the record's closed and you didn't anticipate receiving any more information from either the applicant or from the public. So it's an unusual request in that the timing is not what you would normally see. So that said, I think you have the discretion. You always have the discretion whether to approve a continuance or not. You do in this case as well. The continuance doesn't appear to be related to helping you with your deliberations, and so I think the board has to decide if a continuance meets your needs or not, or if you're simply willing to defer to the applicant in this case. I will note that January 26th, if that is the date that is requested, will mean there will be a different board at that point. So Commissioner Partridge, you would not be available to hear this item at that time. And if Commissioner Thomas and Commissioner Partridge could not agree on a result at that point, then we would need to get new Commissioner-elect Teal up to speed so that he could possibly cast a deciding vote. So it'll be a different board then. But you do have the discretion to continue this item or to simply continue your deliberations today.
Anything further, Commissioner Layden, before we go to Commissioner Thomas?
Not at this time, thank you.
Okay, very good.
You know that this is certainly a frustrating situation we're in now because I was prepared to come back and deliberate with the new information we had, which was what I had made a motion and Commissioner Layden had clarified of what we needed to get this approved. I am concerned that it will come back before a different Board of Commissioners. But on the other hand, this is a large development in our community, and I feel that we need to do what we can to work with our developers, our applicants, to make sure that everyone is successful. And if the applicant is not in a position that they want to go forward with what we ended with on Tuesday, I want to be sure that we are not setting anyone up for failure.
I'm wondering, Mr. Chair, and perhaps this is a question for staff or for council, whether staff would be able to provide us some additional information as to why the continuance was requested, and perhaps give us an update in terms of any information that we have received since our last hearing.
This is Jeanette Baer for staff. I'm not sure what the basis for the request for the continuance is. I don't know if it's, we provided the draft red lines to the applicant along with you yesterday, and staff had worked with Mr. Lytle, the attorney's office. Planning had worked with him to kind of refine this draft to meet the direction that you had provided us to get that additional information. So we can certainly go through those changes if you'd like, but I don't personally know exactly what the continuance request, what the basis of that is for.
And Commissioners,
I guess Terrence Quinn has some information from the email as to why the request.
can you pull it up? Pull the email up. Received, Commissioners, this is Terrence Quinn for staff. We received an email from Brock Smethills outlining why they wish to continue at this point. Brett, I believe you received that email also. Is that correct, sir?
That is correct.
Do you have a summary of that you could provide now, or shall I read the email directly?
I can summarize.
Thank you, Brett.
The reason for the request stated in the email is the applicant noted the changes were substantive, and they've not had enough time to review the changes. They believe the January 26th would give the applicant enough time to adequately review the red line comments that were submitted by staff.
So
Well, go ahead, counsel.
I hope the record's clear, but just to be clear as I can, staff following Tuesday's continuance understood that the board wanted to see some changes to the document that was in front of them, the water appeal that was in front of them, consistent with comments made by Mr. Lytle and consistent with the deliberations of the board. So what is in front of you is staff's attempt to summarize what we think you wanted. So we don't pretend that it's perfect. We think it's what you asked for. We hope it is. That said, the only materials you've been provided is that revised document, I believe in red line form. I'm getting nodding from staff, and our hope is that that met what you asked us to bring forward. But staff doesn't have additional comments or thoughts or presentation. We're trying to bring you what we think you want, and we'll go whatever direction you ask us to go from here. But the only materials that were new, and they were submitted to you electronically yesterday, and I think they've been made available online at this point, is that summary, the changes that we think you asked for. So if we missed, our apologies. That was not our intent, but that's all that's changed between Tuesday and today.
Okay, that's helpful. So my recollection from our last hearing, and I'll rely on staff, counsel, and my colleagues to correct me if I'm wrong, is that we were entering into deliberations to discuss whether or not we would accept this application for an amendment to the water appeal with an amendment to that appeal that would reflect the additional information that Mr. Lytle had requested of us. So I recall that being sections 2.3, 6.1, 6.2, and 6.3 Can staff clarify whether or not those modifications were made to the water appeal? And I have it in front of me. If staff can clarify.
This is Brett Thomas for staff. Sections 2.3, 3.3, 6.1, and 6.2 were amended as provided in the red lines that were provided to you.
And were all of those changes the changes that Mr. Lytle requested of us and also was comfortable with in terms of his review? Or were there?
Yes.
Okay.
We worked with Bruce Lytle on the revisions as well as with staff in preparing the revisions.
Okay. So I believe on the record in our last hearing, I requested of the chair that we might be able to ask the applicant a question, perhaps, once we were in deliberation and had an opportunity to review those modifications. So if it's appropriate, and we are in deliberations now, from my perspective as one commissioner, I would certainly have been a yes on this particular application with the changes that have been submitted. And so I guess my question of the applicant today would have been whether or not they are comfortable with reasonable modifications to the water appeal so that the county can receive the information that was requested. So I think that puts us in a slightly difficult position today if we're unable to hear from the applicant on that level, or if they are, it sounds like, requesting a continuance.
So there would be two questions. It's my understanding from training we've received from the county attorney that once we are in deliberations, getting input from anyone is inappropriate. Second of all, when I read the packet last night, I see the change includes monthly indoor and outdoor meter data, whereas Mr. Lytle was clear when he said daily data is what he needed. So I'm not clear if this is what Mr. Lytle feels is appropriate or not. So he's the expert that the county uses to advise us. And so I had that question. So I don't know if we can ask those questions, because it's my understanding in deliberations, we no longer have the ability to ask questions.
Thank you, Madam Commissioner. You are correct. The general rule is after the board has closed public testimony and taken it into its own hands to deliberate, you would generally not accept information from anyone on either side. The sides are generally the applicant and the public. Those are the ones that tend to offer information that is substantive in nature. You can ask your staff questions about the draft that's in front of you, and they may know the answers to your questions. Now, that said, we are never so rigid or limited in our process that you don't have the authority to reopen the record for the limited purpose of asking questions if you still have them, if that meets your needs and if that would help you deliberate. The risk you take, and it's a risk that's yours to take, is that in the event you receive information that you believe is broad in scope or broader than you intended, then you have to ask yourself the question, do we need to open this up further to allow others to comment on what you've received? So there's always a risk that if you open up the record that you're opening up wider than you intended, but you alone can take that risk. So it's entirely up to you if you think it would be helpful.
Mr. Ingalls, thank you for that explanation, because that I do believe in that process, and that's why we went into that discussion and would not allow any, I made the statement and put it as the direction that we would not allow any new information. But with that, any new information, anything coming in, I believe, proper due process would be to not only have the applicant the ability, the board always has the ability to ask questions, but also for the public to have the ability to address the board. So I think that's what I would say is before us. So, and I'll just have to comment, since we're in deliberation and I know Commissioner Layden, I think a lot asking for staff has brought forward to us, and also what I had asked for, and I had a challenge with the regarding the statement in 2.3 and a few other places where it's or outside the property, because I really get challenged with that, or it doesn't say and. So that has been removed, and I think that is more sensible. So I like the changes that have been presented to be able to make a decision on. And so I have to say I am not so inclined to approve a continuance. I think it's a challenging thing whether it would be justified or not. I think it's a very difficult application that we've continued, and I think it makes it very difficult for a new commissioner coming in to hear, and where the individual will only be in office for a few weeks and know they're already going to be drinking out of a fire hose. So I believe what we have presented, I would be comfortable continuing deliberation on.
Thank you, Commissioner Partridge. I understand your concern. We have all been new commissioners and understand that huge cliff. But I think this would be inappropriate for us to impose this on a developer without their input on it. And again, I'm not sure if this is what Mr. Lytle feels is acceptable or not. So I would be in support of a continuation. As frustrating as it is, I think it is the right decision.
So that's really good input from both of you, and I really respect your thoughtfulness on this. I know that as commissioners, few others understand how much time and effort goes into dotting every I and crossing every T, and I know both of you do that very well. Commissioner Thomas, you raised a good point about not knowing whether or not our expert was comfortable with the modifications that we've seen here from staff. And that was why I asked the question of staff whether or not he was comfortable, and I think I heard you say that he was. Is that still your understanding?
That is correct. We
Okay.
went through the draft and all the changes with Mr. Lytle, and Mr. Lytle obviously is on the line. He is, consultant to staff, so he could speak for himself if you wish, but he went through all those changes and found them acceptable, and felt that the monthly metered data was a good compromise that he could live with, and that would give him sufficient data to analyze a request.
Well, thank you for that, but I'd like to keep it fair and probably consistent with council's recommendations, not reopen the record on any level. But as Mr. Ingalls indicated, certainly we can consult with staff here today in our deliberations. So relying on your representations that Mr. Lytle is comfortable with the modifications, specifically the daily to monthly, which I believe Commissioner Thomas raised. These are substantive changes to a water appeal. And again, I would reiterate, I think the hope was a reasonable request for information from the developer that would create an opportunity for us to be able to get the information we need and render decisions appropriately. I think that's still, I think reasonable information for us is still an appropriate request. And again, I'm prepared to vote yes on this application today, now, with these changes. So I guess the question I would ask of the applicant is whether or not they would be comfortable with that. And maybe what we're hearing based upon the email you read is that they are not. And that they would still, that they would not be okay with these changes. So I think it's two questions before us, whether or not we're okay with continuing it for more information, or whether or not we would simply deny this application for failure to get the information we requested.
Commissioners, this is Brian Connolly, and out of respect for your process.
Wait.
Order. I'm sorry, Ms. Connolly. We are in discussion amongst the board only.
Thank
Commissioners,
you.
we're willing to withdraw the application.
Mr. Ingles, as I understood from the attorney representing the applicant, the statement was, and I would just ask to verify that now it sounds like we have the position of the applicant to withdraw the application.
Yes.
That is what I think I'm hearing as well. If the board would like, if you'll take a 5-minute recess, I will get on the phone with Mr. Connolly and learn more about that position, rather than try and guess as to exactly what they mean. What I'm guessing it means, which is not my advice, is to go on a guess, but I'm guessing they would rather withdraw the application than have a vote on the application as amended by the board.
Very well.
Mr. Ingles, is it, just as a point of order, Mr. Chair, is it timely and appropriate for the applicant to interject and make that request?
Again, I think that's a board decision, and I think it's a fair question, so I can't give you a clear yes or no answer. In general, I don't think the county has ever prevented an applicant from withdrawing their application if that is their desire to do so. In this case, there's a question that if you vote on the application, could they still withdraw it or not? And I don't think procedurally that's clear. So if they wanted to withdraw their application rather than proceed to a vote, I'm not aware of the county ever denying a request like that. But again, I'm guessing that that might be their request. That's not clear to me.
Okay, I just wanted to clarify that they were permitted to do that during deliberations.
The board could permit it.
Okay, thank you.
So let's go ahead and take a 8-minute recess and reconvene at 2:35.
Excuse me, could I make a comment?
Yes, Commissioner Damas?
So if I can just reiterate what we just heard, is that Commissioner Layden had made the statement that he was prepared to vote yes on this situation we have now, or what was the other? You gave two options, Commissioner Layden.
Sure. Well, to clarify, if this is helpful, I was prepared to vote yes on the application, but I was clarifying that before the board, we had the option to, if the applicant was not comfortable with these conditions, the alternative option for the board would be to turn it down.
Okay, so let me just make the comment that I think there's a third opportunity, which is to continue it, which is what the applicant did before this hearing. And staff and the applicant side have both spent hours working on this, many hours. And so I think there's a third option on the table, which is the continuance that they requested until January 26th. And I believe I have said on the record that I am supportive of a continuation, and I believe that Commissioner Partridge said you were supportive of a continuance. Is that correct?
No, I would not be in favor of continuance.
Okay, I'm sorry, I misunderstood you. I thought you said that you would be in support of a continuance. Okay, then I am okay with going into a break for the attorney, for the county's attorney to confer with the attorney for the applicants to decide what they want to do. But I just want to say that I think if we put the applicants in a position where they have to withdraw this, I think it's really sad for staff and the applicant who have spent hours and hours trying to get this done, that we can't figure out how to do that. So thank you.
Great. And let me add, I'm not opposed to a continuance either, but I think I would need to hear that it was procedurally and legally appropriate to do that. So maybe the recess will help us with that.
There will. So we will recess again until 2:35 p.m. Good afternoon. We will reconvene our meeting at 2:36 PM. And Mr. Ingles, I believe you've had a conversation with the applicant's attorney, Brian Connolly.
I have, Mr. Chair, thank you. So to clarify the request, their preference is for the continuance that they asked for before the hearing. In the event the board is unwilling to grant the continuance, they would like to withdraw their application.
Very well. So from what I'm hearing, I think it would be sensible, we've heard from Commissioner Thomas and myself, and since we're actually in deliberation of the request to continue, we can kind of make our general statements, and with that, I think we'll probably have an idea of where we would go from there. So Commissioner Layden?
You know, I think it's helpful to hear from staff and council, and this is important, and ultimately it is the future of Douglas County. I think that it is wise for us to be thoughtful about this, and so for that reason, I would be open to a continuance.
Okay, so I think we pretty well have an idea. So I will entertain a motion.
And just to clarify from staff, the time of that here, or the date of that hearing would be January 26th at 1:30, I'm sorry, probably 2:30 PM. So I will make a motion, Mr. Chair, if the board is prepared, to continue the amended and restated Sterling Ranch water appeal as amended by the board on December 18th, 2020, project file MI 2020-010 to January 26th at 2:30 PM.
January 26, 2021.
2021, did I say 2020? Oh, no.
No, you just.
Oh, okay, yeah, I know.
Very well.
2021.
Second.
So we have a motion and a second. Any further deliberation? All in favor, state aye.
Aye.
All opposed, say nay. Nay. The motion passes 2-1. This item will be continued to January 26th, 2021 at 2:30 PM. That concludes our items on the agenda. We are adjourned.